All right, Cherokee Nation, you're fucked. You lied. I have it right here. You just should put this on the record. You don't send it. You don't tell nobody. It'll do nothing. I put all this evidence on the record that you guys have no jurisdiction. The Bar Association can't be judges. The missing 13th Amendment. I heard you guys mumble at my radio station to each other. And about, have you talked to Treasury today? And the fact that I'm following all these rules. You said if you would have read the rules, and you ran and hid. Well, it's been since May, and you keep throwing it to the next month instead of making a decision right there on what you're going to do, because clearly you got no authority to do such. So Cherokee Nation District Court, again another district court, is a private corporation in all capital letters. The District Court of the Cherokee Nation, right there in all capital letters. So they said you should have a motion hearing. Well, I put in for a motion to dismiss like 2 months ago. Well, about a month ago, if even that, a few weeks ago, we go to court, right? And he goes, oh no, we moved it to next month. You should have done it in a timely manner. You should have read the rules. It said any time. You have to do it specifically during these certain... No, the prosecutor's lying to cover his ass. You guys have never proven jurisdiction in 200 years since you guys stopped with the original, the original jurisdiction of the Supreme Court hasn't been in 200 years. You ain't got shit. But let's get into it. I went under Rule 123, which I will show you exists in their rule book. Maybe it's number 123, but motion titled the motion to dismiss. They did a deflection, and they're not showing anything whatsoever. Which they would, if they look in their own rules, they don't. If they violate every day, they would see that I can do it at any time for lack of jurisdiction. So let's get into what they respond to my motion hearing. So now I'm not even going to show up tomorrow, because they're just going to try to book me or something. If they responded this about a week or two ago, before this motion hearing. Now, I'll get the name I'll read you everything of the cut criminal that's going to put their name on this fraudulent piece of paper here, right? And she's going to stample and file it, Cherokee Nation District Court, Christy Moncoya, court clerk. So the court clerk's doing this fraud. You're doing the SPF bond forms with my social security number. Each fucking charge is a bond. Appearance bonds, all this other bullshit. But they're lying. So no, I will not be appearing and giving you guys consensual subject matter jurisdiction. Because under the threat and duress coercion, 6 months you guys haven't proven jurisdiction. Just stall till the next month and run with your coattails in the wind into your chambers like you got something to hide, Mr. Prosecutor, and your slick back hair. Kind of dressed up like you're the fucking, that lawyer, not real brother off not the ranch, but off Yellowstone. The one that kind of betrayed his father and slick back hair, and he doesn't work and do hard shit like the rest of them. He'd rather be a lawyer or a banker than a motherfucking rancher. Let's be for real. This motherfucker, lazy, fucking dumb, he probably never lifted nothing in his life. His hair's slicked back, his suit's on, he thinks he's doing his job. He's violating federal law, trying to put me in jail because I won't help them generate revenue. I won't just agree to this contract can't sign, or I signed it under duress with VC, and he's trying to say that I signed it, agree to these charges. He put a plea on my behalf. The judge is practicing as an attorney in the judge position. You cannot enter a plea on my behalf. If they have the same legal definition of guilty, non-guilty, and no contest, all in your legal books say that all means non-guilty and you're railroaded by entering a plea at all, then you're fucked. But here's again, when I first tried to file this federal court, the federal district, again, districts where everybody tells you to go for 1984, whatever, in the Title 18s, right? I did Title 18 first, whatever the fuck reason. No case, sovereign citizen rhetoric. This doesn't exist, even though it's right there in federal law. I had a TikTok attorney saying, they think something about, and cops and judges, he thinks Title 18 is a real law. They always do that. It is. It's literally right there, but they don't care. So they just dismissed it, said no claim to which of relief, no case, no nothing. You're stupid. So I said, my motherfuckers didn't rebut or prove anything. Objection. Dismissal. Refile under 83. Well, we're threatening to dismiss again. Again, you're not debunking me. This is not your decision. It's established fact of federal law. They don't want to follow the law, and it's very clear. So Cherokee Nation Court is a liar. Cherokee Nation Court has not provided legal evidence that they have any authority whatsoever without consent. Neither in this document, it doesn't do it either. So if you guys are going to ruin my life, I got a family, I got shit to take care of, we're starving, the government's killing us all, and yet we got to deal with this fraudulent piece of paper. It's a paper. This paper has no authority to do anything. You write crap on a paper and stamp it, it doesn't give it legal or lawful. It doesn't give it lawful authority. Just because you made it up. Now let's get into it. There's me, my all caps again versus their all caps. That's fraud. Oh, I don't know what I'm talking about, but you're fucking putting the all caps name right there. I get mail in the lowercase and in the uppercase, depending on whether it's a bill or not. You fucking cucks. Depending on whether I gave that company my SSN or not. And you guys demand it at booking every goddamn time, and I don't give it to you. You guys go steal it off the records or from the last time. Why are they asking for that when the website of the SSA says not to give it out, and it's not for identification purposes? It's for bank bonds. It's for banking purposes. Clearfield Doctrine, when you start doing commercial banking paperwork, you guys aren't the government and have no authority over the living man. Clearfield Doctrine is real. Title 18, 1980, all these things, they're real. Federal law is real. They don't care, though, because they're a private corporation. They think they're outside of the Constitution because DC and all, I don't care. So here's their response to defendant's motion to dismiss for lack of jurisdiction. They're pissed now. But they get to extort us with these traffic tickets and put them all on the criminal side, violating case law and federal law. They're civil and administrative. And fuck you. You don't get to make some bullshit ass weasel your way Jew response. Fuck no. Actually, find the law that granted jurisdiction. He said, just because you're a citizen, he's a citizen. This is what they do. You're a citizen, you're employed here in the Cherokee. Yeah, under duress, my parents as a minor, contract voids when I become an adult, but as a minor, without full disclosure of losing my common law rights as a citizen. You think that's why shit ton of natives did not register in the DOS? Because they knew what the fuck was going on. It's to be a Jew slave, they signed a contract to be in the register. Now everybody is registered at birth. No matter what race you are here in America at the hospital, the birthing center, the birthing dock, the doctor giving birth out the canal like a fucking boat. Like, god damn. Tons of that, yeah. All on record too. Tons of doctors, lawyers, judges have come out and exposed all this. You got nothing against it, 200 years, but bullshit like this. Now watch how they don't debunk my crap ton of shit I've been putting on the record for 5 months. Paragraphs, case laws, all this stuff that takes forever to fucking read. It's like those big ass high schooler books that most people don't read in elementary, but when you got a 9th grade reading level and you love to read like me at 5th grade or 4th grade, you're reading these fucking high schooler books? Yeah, they're chapter books worth of fucking violations and fucking federal law, and they're just going, nope, it's not real. Our Cherokee rules aren't real, even though we publish them on our website, but they're not real because I said they're not real, and just because I randomly right now said they're not real, you're stupid and you don't have an argument. This is what it is to be an administrative law judge in 2025. You can't prove us wrong, you can't prove that we don't have rights and that these rights don't exist, but you have the balls to just, it doesn't exist because I said so. Common sense would say, show the rule before what I claimed and the rule after, and direct me to that part to try to find where it is. And then you should say, well, respond if you feel that we're incorrect and where the rule is that you're referring to, we're ignorant and stupid and don't check our rule book. But they can't do that either. That's self-incrimination. So they got to double down to scare me and say that it's not true. Because they know my grandma over here or somebody's going to go, oh, come on, they're telling you it's not real. You got to stop now, Nathan. You got to get it out. So if we're really doing this, it's really like half of America, fuck whatever. You know what I mean? Help me the fuck out. Clearly, it's a lie. But now everybody's got their hands up like they don't know what to do, and they're stalling with them too. Do we need to go class action? Do we need to protest and unite at the Supreme Court and say we're not getting lawful redress? Hang on. All right, let me get into it. But clearly, I checked. The reason I did it is because the rules in the Cherokee Nation said that I could do it at any time. And I figured, oh shit, that's there because they don't have authority to begin. Why would they put that there? And for them to come back and say that that doesn't exist at all and there's no rule 123, or there's no number 123 that says motion to dismiss, doesn't exist in the Cherokee Nation district rules, well, that just means because in the rules it tells you exactly how to get out of this fucking bullshit, and they can't have that because everyone else will discover it. It's a money-making thing. They've been generating a quota of revenue all this time, and I'm putting a fucking nail in it. I'm done. We're broke. We can't afford it. We're broke. We're selling our houses to pay tickets of unconstitutional, non-violent traffic infractions, or stuff that's protected under the federal law and the Constitution that most cops are standing down from. Oh, I just do what my boss told me. I don't care what the neighboring sheriff does and what federal law is. Yeah, comes the Chad C. Comes now. I have to say comes now to sound professional in Old English. This is Old English bullshit. This is the British people. Comes now before ye. Might as well say it like that and put ye. They're lazy. You know what I'm saying? They don't care. They don't care to research. They just want to, you're a lawyer, you're a lawyer. Well, how am I a liar? Prove it. I can't, but I'm the judge. Or who is this? Attorney General. A liar. You attorney generals know this is true and continue to show up to work every day. Fuck you. You can only go after if I damage property, injure somebody, or murder somebody. These traffic tickets are illegal. At the very least, at the very most, civil and administrative, according to your own federal law. Most of the shit. Hell, I even looked up, I wonder where the wildlife codes, the wildlife signs down there. They lost the three-letter H, another one that lost authority with the overturning of Chevron. So I looked it up, and it's under Oklahoma Administrative Code. A lot of this is under Oklahoma Administrative Code. And there's sub-branches. Fuck you for acting administratively and lying on paper. And I have the copy. So let's get into it. This is the acting, duly elected and acting. So how are you an elected, like the official, and acting? Usually an acting attorney general fills in when they don't have an elected. An acting judge is not the judge. They're all acted. They all put that in there because they're all acting and we haven't had real government judges, whatever, since 1895, right? Civil War, right? It's one of those two. It's right in there. 1890, 1895. I don't fucking care. And they've been private corporations ever since. So yeah, that's on record. The missing 13th Amendment. That you never unratified, deratified, removed, decommissioned, whatever. Yet you just kind of removed that out of reprints of the Constitution and threw in like the 14th, 15th, whatever. These amendments that legalized slavery that were never ratified by the proper amount of states. The 13th Amendment says you guys with bar, title, and nobilities have no authority in the courtroom. Have no authority to issue warrants, prosecute, any of that shit. Wrong venue, void judgment, fruit of the poisonous tree. Fuck you. We're winning in every district court that there ever fucking is in America. Fruit of the poisonous tree. And if you don't understand it, you're just lying, thinking that I'll give in. It's been 5 months, bro, and honestly, I've been doing this for 10 years. Fuck you. Never get bothered without having a license. And now that you've caught on that I'm beating this shit, we're going to just keep racking up charges. And we're going to tell Cherokee to stall on them a little bit. Comes now, Chad C. Harsha, Harsha, the duly elected and acting Attorney General, oxymoronic. I don't think you can be acting in place of a duly elected official as a duly elected official. We elect you to be the Attorney General, not the acting Attorney General. That's in the meantime, like he dies, and we need an Attorney General to prosecute this stuff. Acting Attorney General. Or if you're just all private corporations and everybody's de facto sheriffs on record, de facto corporations acting as government on record. So this is what's going on. Duly elected and acting Attorney General of the Cherokee Nation, and then they put nation again in parentheses after that. Like this is the lowercase side now. But at the top it's capital letters. Can't do both, guys. And through Assistant Attorney General Cody Boland, who also, by writing this document, is lying and covering up the criminal organization known as the Bar Association and these fake courts. So he's doing it too. Respectfully, of course, I found out now that when you say respectfully, that's like a nice way of trying not to cuss someone out or call them an asshole or tear them a new one. You know, you're trying to, respectfully, you're wrong. Sorry, I didn't know that at first. So, respectfully submits this response in opposition to the defendant's motion to dismiss lack of jurisdiction. Defendant requests that this court dismiss this case pursuant to Rule 123 or number 123, semantics. You guys love that. Of the Cherokee Nation District rules. However, no such rule exists. The Cherokee Nation District Court rules contain no Rule 123. Semantics. They don't say no rule that says you can dismiss at any time for lack of jurisdiction. Even though it is 123, and we'll get into that in a minute, they don't say that. Defendant fails to cite any valid authority supporting dismissal. That's the most valid thing ever, is that the case can't proceed without jurisdiction. You have to have it. And if you hadn't had it in 200 years, I mean 200 years of fraud. For this reason alone, for your semantic deflection to cover your ass, I'm in federal court with it. You want to rob me of what dime I have left? For this reason alone, deficient motion should be denied. Should be or is. And if you have no jurisdiction to deny it, it says I can motion to dismiss at any time. It doesn't say in that rule that they can deny. We'll see if the judge gives approval. Anytime. I don't care. Cherokee Nation, let's see, Cherokee Nation Code established procedures for dismissal of actions. The defendant's motion does not rely on a reference of any Cherokee Nation statutory authority. Instead, the defendant presents unsupported assertions regarding jurisdiction and procedure. Since you guys want to ruin my life, it's time I come with receipts. Subject, and you're doing it to everybody. Everybody that's in there, 70% don't belong. Subject matter and personal jurisdiction. Here we go. Defendant contends that this court lacks both subject matter and jurisdiction and personal jurisdiction. It's on record. These type of courts don't. They're they're fake courts, or corporations, quasi-governmental, whatever. But your rules say it too, so it's whatever. You're gonna lie, and that's fine. Defendant contends that this court lacks both subject matter jurisdiction and personal jurisdiction. This argument is without merit. No, they have to use that specific word. So ask. The Cherokee Nation District Court is a court of general jurisdiction. No, it's not. Empowered to hear cases and controversies arising under the laws, here we go, bullshit, of the Cherokee Nation. See 20 CNCA, subsection 11. Cherokee Nation Court. Cherokee Nation, I don't even know what the fuck that is. I don't know. And look, this is their argument. Defendant is a citizen of the Cherokee Nation, and the alleged criminal conduct occurred within the boundaries of the Cherokee Nation Reservation. These facts squarely, just because I'm a citizen, nope. They get to rob me under the color of law with traffic infractions. They're not crimes. And they put them on the criminal side. Establish both subject matter and general jurisdiction and personal jurisdiction over the defendant. Moreover, the case law cited by the defendant regarding personal jurisdiction is wholly inapplicable to the issue and provides no support for dismissal. They don't explain why. Insufficiency of process, failure to state a claim. That's number 2. Defendant next tosses out vague accusations of insufficiency of process, failure to state a lawful claim, without offering any explanation. I don't need an explanation. You guys didn't state a claim, and I did provide explanation. That's in my paperwork. What the fuck? The best guess is that he's attempting to invoke Federal Rule Civil Procedure 12B6. If so, it's worth noting that this federal civil rules to weed out malice civil lawsuits. Yeah, right. Deflection. Neither of which describes this case. Deflection. This is criminal matter. Sorry. In Cherokee Nation District Court, no, it's not. Traffic infractions aren't criminal. No license and registration's not criminal. All the obstruction and all that crap is just bull crap to cover his ass. It's physical, and I didn't do any of that. I invoked my right to non-ID in a non-ID state. Get the fuck out of here. This rule has no more relevance here than Rule 123, which again, their claim, they double down on it, or if it's not the third time in the thing, does not exist. Defendant's motion lacks any basis in law. Of course. Not true. Defendant identifies that no Cherokee Nation statute rule relevant legal authority supporting dismissal. I don't need a Cherokee Nation statute. Fuck you. Statutes aren't law. I provided that case law as well, and they still... Instead, they rely on non-existent tribal court rules. Yeah. federal civil procedure, neither of which govern this proceeding, because defendant's motion is unsupported by law, fails to not grounds for dismissal, relies on inapplicable legal standards, and is wholly without merit for the foregoing reasons, defendant's motion shall be dismissed shall be denied in its entirety. Well, I object. And I object on camera, whatever, all of it. I object every which way, shape, or form. You didn't prove anything. No court rules, no nothing. Before we show you they lied, let's first show you referring to here. What referring to in this other here. Let's go here, since they want to lie on have an oath. But no, we've played the Gregories. They've done all the research there. There's no oath of office. But look, 20. Caps lock. C. N. C. Oops. C. A. Subsection 11. See if it has anything to do with it. Okay. This says Title 20. Make sure I'm right. Yep. Of the Cherokee Nation Code, annotated CNCA, not the court code. So they're not even. It's not the court rules. They just randomly citizenship gives jurisdiction, but an unrelated thing up there. Literally said CNCA subsection 11 of Title 20. Defendant is a citizen in alleged criminal conduct. They had to put that alleged criminal conduct because it's not criminal. So I object to that. People versus Brown, people versus Battle, and federal law. Occurred within Cherokee Nation. That fact squarely established. No, it doesn't. So you can see the screen here. It says specifically addresses public action for the support of the deceased parent's child. Provision found related to the obligation between children. There's Title 21. Now let's just try to find the whole thing. It is a court thing. It says Title 20 courts, but and look, corporation right there. It's going to download it. Oh, no, it's going to open it over. Okay. Judgment of tribal courts. Any courts of Indian offenses in law and order code. There's 25 subsection 11, application and jurisdiction, but they put 20 subsection 11. So they don't know what the fuck they're doing. I think it's 20. I don't know. I don't want to look it up because Rule 123 might actually be in there. Proof right there. I don't know what the fuck they're talking about. See, look, Rule 20. I can't find rules up. We'll get to it. There's criminal procedure. Yeah, this isn't district court rules. This is just based off the Code of Federal Regulations. So if they're going off Code of Federal Regulations, look, this is Oklahoma statutes. Not the Cherokee Nation rules, which the prosecutor tried to say, well, we're sovereign, we're Cherokee, we don't do the U.S. law. A GRDA cop stopped me out on the road, not a Cherokee Nation, which they don't stop people, and charged me with a state statute under the United States. And your rules say that you can charge or deal with any Cherokee Nation that's charged with any Cherokee rule, law, whatever, state rule of Oklahoma or the United States. If it's right here and they throw you over on McGirt. Stop playing with me. So he lied and said that they're their own thing, charging me with their own law and statutes. No, I wasn't stopped by tribal cops and took in on their own thing. I was stopped by regular cops. Not even that. GRDA has got limited jurisdiction, private property, and the land that they own only, not the highways. Yet they're on the highways. And look, tribal reassumption, you got to reassume, of jurisdiction over child custody proceedings. Again, this is the federal U.S. code for you cucks up there at the courthouse. Indian Tribal Justice Support, 25 U.S.C. So let's get it. General positions. Chapter 1. Let's get into what they fucking put on here. 11 CNA subsection 27. Any action by district court Cherokee Nation standard of review. Okay. Courts may appoint interpreter. Several courts of this nation shall, whenever the presiding judge may deem necessary, appoint consecutive interpreter. Witness qualification oath. Not excluded upon the grounds of interest, not otherwise qualified by law. Will be called as a witness. Cherokee Nation Court. Mr. Examination. So help you God, right? You know what I mean? We have to tell the truth, but they don't. Cross-examination. Weird. Non-attendance of witnesses. No excuse for non-attendance on the part of a witness duly summoned to testify for any court shall be deemed lawful and valid unless satisfactory showing made to the court that obedience to the summons was impossible or would have been attended with serious and unavoidable loss or with probable and serious danger to his own health or to the health of his family. Hospital. Get the fuck out of here. Constant fees. Application of purpose. So here we are, Chapter 2. I don't see 20, unless we're still in 20. District Court Jurisdiction and Procedure. This is federal rules on Cherokee courts, not the Cherokee rules on top of that, which, why the fuck is there federal rules and Cherokee rules? They conflict or whatever. The purpose of this chapter is provided to establish Cherokee Nation District Court of general jurisdiction. In cases, controversy arising under the Constitution, treaties, and law of the Cherokee Nation. See, Constitution, right there. Decisions of the Cherokee Nation Court will be subject to review by Cherokee Nation Supreme Court as the court of final review. That's bullshit. District Court Cherokee Nation shall be composed of one or more district judges and associate judges to be appointed by the principal chief confirmed with the council needed for orderly administration of justice. There it is. Any citizen, Cherokee Nation is a member in good standing of a state bar association who has never been convicted of a felony shall be eligible for a district judge. District judges and associate district administrative law judges shall be appointed for a term of 4 years. Previous appointment service by district judge shall not disqualify. Continue appointment. Oath of district judge. Any district judge or associate district judge shall, before entering upon the duties of office, take and subscribe to the following oath or affirmation. I do solemnly swear that I will faithfully execute the duties of District Judge of Cherokee Nation and will, to the best of my ability, preserve, protect, and defend the Constitution of Cherokee Nation of the United States of America. Well, clearly not the United States of America. I swear to affirm further that I will do anything in my power to promote the culture and heritage tradition of Cherokee Nation. Lowercase. Why is there a corporation that they have a secret oath to? So, you know, what's going on? Again, lowercase Cherokee Nation, the republic, you know, the constitutional side, the private side, the we the people side. You notice how it's not always in capital letters, but here on their paper they had to do that. They had to put me in capital letters because that's the elitist. So you guys didn't debunk all that. It's on record that person is a corporation in all the statutes. I'm not a corporation. I'm not a business. I'm alive. Disability of vacancy officers, judge, who cares? There's that. This salary district judge will be fixed, officers permanent, judge. District court judges are exempt from any disciplinary action to the Human Resource Department and policies and procedures. Such judges may only be disciplined or removed under the provisions of the Constitution, Cherokee Nation, or applicable statute. Any district judge is removed from office from Cherokee Nation Council of Cherokee Nation may recommend the removal of any district judge from office if the opinion of the district judge council is because the judge be guilty of malfeasance of office, neglect, duty, mental, physical incompetence, performance. Seems to be all of that today since they lied. Nothing here. It says because I'm a citizen, the court can make up charges and make up fines and force me to pay ransoms and fines or go to jail and steal my money. That's some Jew usury. I didn't injure anybody, didn't commit a crime. Traffic infractions, civil things aren't crimes. You don't just get to decide. District Court deemed always open. Effective sessions. District Court deemed always open for the purpose of filing papers, issuing and returning process, making motions and orders. He said I had to do it at certain times. It's always open. Fuck you, prosecutor. Continued existence of expiration of session of district court in no way affects the power of the district court to do any act or take any proceeding. Judicial conference, justice shall attend the annual judicial conference. Yeah, they used to have these conferences, right? Where they would tell you how to handle us to avoid lawsuits and losing your position for violation of rights. Just to shove us out of the way with the dismissal or prevent from being heard by the rest of the people you're extorting. We got former judges say, yeah, we had to go to these meetings. Fuck out of here. Here's generally, jurisdiction. Subsection 24. The district court Cherokee Nation shall have general jurisdiction that is vested with the original jurisdiction. Whoa, hold on. How's the district court have original jurisdiction if the Supreme Court's the only one in the Constitution that has original jurisdiction? That's impossible. So anyway, not otherwise reserved to the Supreme Court. Wow. So yeah, normally the Supreme Court has original jurisdiction. They're claiming it at the district level, which is a violation of the Constitution. District courts aren't in the Constitution, and they're listed at most state websites as quasi on the little graph, the trickle-down graph. To hear and resolve disputes arising under the laws or Constitution of Cherokee Nation, both law and equity. So there's equity right there, law and equity. They called me a liar, but I wouldn't put that on there too, but law and equity. Equity. Value of asset after liability is suspected. So yeah, there's equity here. Whether criminal or civil in nature, sections shall include but not limited to the following. Crimes, all violations of the criminal code of Cherokee Nation committed within its territory jurisdiction with the following categories. So here we go. Follow the Constitution. Here's what they list as crimes, and I'll name off the ones that I know for sure are not crimes. That we all know. All crimes, all violations of the criminal code of Cherokee Nation with the following categories. A. Offenses committed by Indians, as defined by federal law against all others, Indian and non-Indian. Automatically a crime. It doesn't tell you what it is. It doesn't say it has injury or non-injury. Offenses committed by Indians, again, we're natives, not Indians, as defined by federal law, which are victimless. So there don't need to be a victim. So I mean, yeah, play this in front of the judge. That's a violation of the Constitution. It says there's got to be a verified complaint of an injured party by victim. You guys can't be the victim, the injured party, the judge, and the prosecutor. Holy shit, Cherokee Nation. That's a crime. But oh yeah, you put it in your own rules to violate the Constitution. That, it's a crime not to have a victim. Without physically injuring somebody or financially injuring them, they can just make up that they're injured by you and then claim a victim, put it on the criminal side, a victimless crime. Sorry, but crimes have victims. Crime is a victim. That's what crime is. You go rob somebody, you go destroy their house, or cause damage to their car by an accident. That's what crime is. It's doing the harm to others, or a financial loss to others. There is no victimless crimes. The state is claiming to be the victim in these or to be the injured party. In all cases where states are party, the Supreme Court of the United States shall have original jurisdiction. So how the hell you got original jurisdiction at Cherokee Nation and was able to put it at the district below the Supreme Court is crazy. And I think that's what's going on here. And I'm native, not an Indian. You didn't tell me the difference. Civil cause of action. All causes of action which arise within the territorial jurisdiction of Cherokee Nation within the following categories. Between all parties, Indian and non-Indian, by whom their actions have submitted themselves to the jurisdiction of said court, and when the defendant is Indian, as defined by federal law. So where their actions have submitted themselves to the jurisdiction of said court, none of my actions have. When the defendant is Indian, defined by federal law. I'm a false pseudo-definition. You change the rules from native to Indian, doesn't give you jurisdiction. Domestic relations. All cases involving domestic relations, Indian child care, who cares? All child support care, who cares? All other matters, miscellaneous. All other matters with jurisdiction as heretofore vested in the Cherokee Nation District Court, or which may hereafter be placed within jurisdiction of said court by council. Oh, territorial jurisdiction of the Cherokee Nation shall extend to include all Indian country, known as Cherokee country. All of Indian country is like the whole state, but whatever. I don't know, Cherokee country is just the east side. Within the 14 county area, northeastern Oklahoma is divided into treaties of 1828 and 1833 and 35, patent of 1838 between the United States of America and Cherokee Nation, a patent for a fiction, and at such other location within the United States which qualifies Cherokee country. So there's other places outside these 14 counties that qualifies Cherokee country. I don't know. That's interesting. Writs or orders. Let's learn how that works. District courts have the power to issue any writs or orders necessary to proper complete exercise of jurisdiction. Power to adopt all rules as necessary for proper complete exercise of jurisdiction proceedings. Reimbursement of expenses incurred by members of the Supreme Court and with disclosure. Reimbursement. Maintain and oversee, control law library, the Cherokee Nation courthouse, law wires, scan books, publication, research, deemed necessary by Justice, Supreme Court, associate district judges, including but not limited to electronic research aids. Cost of such law wires shall be paid from the budget of the Supreme Court and the District Court. When such books and publications are not being used by the Justice, Supreme Court, and District Court judges, associate judges, of the Cherokee Nation, or their assistants, such items may be used by the citizens of the Cherokee Nation. On such conditions and rules are adopted by the Supreme Court. The offenses occurred, I don't care. There it is. Supreme Court should have original jurisdiction, even though earlier it said it doesn't. It's outside of the Supreme Court. The District Court has original jurisdiction. Well, this says the Supreme Court shall have original jurisdiction over all matters set forth in Article. Come on now, Section 4 of the Cherokee Nation Constitution, VIII. Let's see. Any dispute between the branches of government of Cherokee Nation. Any case contrary involves Cherokee Nation elections. Cherokee Nation Commission. Supreme Court shall have appellate jurisdiction over all of the case. Okay, to the Supreme Court. All statutes which belong to the Cherokee Nation was concerned contain the term Judicial Appeals Tribunal shall be changed to Cherokee Nation Supreme Court. So it's a tribunal court. Judicial Appeals Tribunal shall be changed to Cherokee Nation Supreme Court or Supreme Court where applicable. So they just changed the name. They're still a tribunal. Cherokee Nation rules say tribunals are allowed. I don't know. Superintendents over courts of inferior jurisdictions. The court shall have authority within the limits of its judicial actions prescribed by law to exercise general supersedence over courts of inferior jurisdiction. Here we go. Right? Through and by means of decisions made and declared by Supreme Court upon questions of law, evidence, practice, submitted into them in the course of the trial, by explanation of all causes of which they shall be allowed or organized by law. Now let's put that on screen. That is, subordinate court decision can be appealed to a higher court. This court simply of limited jurisdiction. Yeah, good. And they can prescribe rules for inferior, and they may not conflict with the rules prescribed by law. Right to travel. No jurisdiction. All they can say is, oh, the law that he provided is, whatever. It's real, guys. It's not real. We'll get to that. Hang on. We're cooking up, Judge. Supreme Court decisions that the force of law, I'm just double checking all this so they all witness, all my fault. All decisions made in court of the force of law shall have the force of law. That's the construction and application thereof in all courts of this nation. Until such construction or application shall be limited, altered, or any other manner amended by the Supreme decision in the case of the Supreme Court. And I provided evidence of how they're limited, but just whatever. Publication of decisions of the Supreme Court. Decision to be rendered for the true interpretation of the law. All decisions of the Supreme Court, intermediate and final, shall be made and rendered as well for government and guidance of the lower courts of citizens of this nation in general, as just from the true interpretation of the law, settlement, dispute, and administration of justice between the parties. Accordingly, each decision shall be a compromise with a statement as far and full may be practicable, and serve the purpose of ground of law, evidence upon reason which such decision has been made. Each decision shall be attended. Come on, I gotta read faster than that. Nothing there. Justice shall adopt rules, pleading, practice, procedure. See? They're adopting the rules of the pleading and the practicing of the law and procedure, applicable to all proceedings. Any or all proceedings, Supreme Court and Court of Cherokee Nation, in addition, they may thereby adopt uniform rules for the admission of evidence and may require the use of standard forms for pleadings, motions, or the right here, any rule adopted by the judge shall be transmitted to the council directing the codification of such rule. No rule adopted by a judge shall be effective until approved under procedures adopted by the judge is transmitted to the council. Nothing in there saying that they get to just make up whatever rules they want, and because I'm a citizen, I have to follow it. When the federal Supreme Court of the United States said otherwise. Assignment of deposition cases, making appeal. Motions of reconsideration. In any case, that's all. Filing fees. Hang on, service. Time for filing of motions. Tired, folks. This is bullshit. The Chief Justice ruling is provided in Rule 11, and all other judicial rulings and orders shall be issued in writing and a copy served on each of the parties. Justice several motions after the opening of the hearing, which they never done. So stated claim. All motions will shall be record. He stood there recorded on record at first. The first judge I had. Come on now. Now I think I have him again. And look right here. There it is. Rule 43 here on the federal rules governing Cherokee Nation courts of the United States. But that's not where I looked up Cherokee Nation District Court, where they specifically said in their Cherokee Nation District Court rules it doesn't exist. No such 1, 2, 3. Nothing numbered that exists. Titled motion to dismiss or what to do. At any time, look, it says the same thing. At any time, prior scheduling or as permitted in the scheduling order, or move for dismissal at any hearing for lack of jurisdiction. Can I just print off that page? They're lying. You know what? Screw this crap. Control print screen. Wow, so we're on paint now, cutting this out, since they said it doesn't exist in the Cherokee Nation rule courts, and they sent me this, the federal rules of procedure for Cherokee Nation. And it's there too! Anytime! The exact same fucking bullshit ass wording. So, yep, you're committing fraud, guys. That's there because you guys don't have jurisdiction without consent. And you're assuming consent just by us being a citizen. That means we also consented to being railroaded financially. So what rule is this? Rule 43. Cherokee Nation Federal Rules Civil Procedure. Bam. Now we go back. Now that's there, and we knew it would be in there. We knew it would be the same. I didn't ever looked in there before. Don't need to. But now we go to the key. I'm just gonna skip down because I got a shit now all of a sudden. I ain't got all night. I have a life, even though these people don't understand we have a life. But let's just show you where I got this from. It's right here. They called me a liar multiple times in this document used in retaliation as evidence, as well as this right here where it does exist. At any time, for no, you know what I mean? If you can, at any time, motion to dismiss for lack of jurisdiction, it's probably in there multiple times because you guys don't have it. If you had it, you wouldn't need it. So, let's see. Same shit. Direct contempt tells you what contempt is. And here we are. Okay, they have a Roman here, but XVI. Motions. In the section of motions, And I got frivolous pleading. Service pleading, dismissal, frivolous pleading. That's probably only for frivolous if I were suing somebody at your court personally. Purpose of the trial order, like agreement. Just go down here, look, number 1, 2, 3. Nothing exists of the such. Nothing in our rules about motion to dismiss subject matter. Yet, Rule 42, or whatever it is, I've said it about the... A lot going on here, so let's just scroll down, shall we? Oh. Look right there, uniformity of rules. When question of law, fact procedures presented to a judge, the sanction so far as it relates to the same case shall not therefore knowingly be presented to another judge, district, without presenting subsequent to judge the former judge's ruling. No ruling has been made that such question has already been presented to the judge. This rule has been violated. Or second judge, I don't know. Any proceeding, vacate, modify, reopen a final judgment that's commenced 130, whatever. Trying. So I ain't going. I got work. I gotta do this radio. Judge, any court shall sit in the case proceeding, the judge may be interested, result whether the judge may be interested, or whether the judge may be related to any party. And interested, the financial interest is the Social Security number, folks, in the fine itself. Any time without the consent of the parties who have made an appearance in such proceeding. No judge of court shall sit in the trial hearing or any criminal case proceeding if the judge related to any attorney of record in such cause with the third degree of consistency, affinity, without the consent of the parties who have made an appearance on the record. And here's how you disqualify a judge. To close any contempt in order to protect the rights of the party interest of the public by see public. So I'm not threatening the public, it's not contempt. By ensuring administration of justice shall not be thwarted. Trial judge. Willfully obstructs the court to its proceedings. Well, they're administrative proceedings. I don't care about none of it, because I'm not being combative at all. Did I pass it? Here we are, motions. All motions shall be filed in writing in the office of the district court, either in person or mail or fax. All motions for summary judgment. Oh, I gotta get the chat up. Well, since let's can't see, you can't think. Court rules. Hang on, district court rules don't have a state time. And I'm often have to ship for lack of subject matter jurisdiction. Bullshit jurisdiction. Also, get my evidence being rule and I searched 20 CNCA 20 CNCA subsection 11. Now let's see. They told me once that yeah, that's in there. Good, so I can do it anytime. Why not? It says in the rules. We showed you the court's always open. Prosecutors, if you would have read the rules, you would have known the time to file. Your rules say they're open all the filing, folks. Ha! They lied about Rule 123 not existing. They ignored your motion to dismiss, even though Cherokee Nation rules say it can be filed any time. They mislabeled your filing under 20 TNCA subsection 11 to dodge jurisdiction. Rule 42 also confirms that motion to dismiss for lack of SMJ could be filed at any time. The refusal to hear it is denial of due process and a judicial misconduct issue. Yeah. A bitch. Holy shit. So stalling. Dead. Folks. Hang on. I can't remember what the fuck I was. Shit! Oh my god. I'm right clicking and it's not doing a little menu. Holy shit. I can't do it. It's going slow. Give me a motherfucking menu. I gotta open it like this. Who cares? computer's freezing on me, bro. I'm not doing this thing. So let's go to the Cherokee Nation. Yeah, that's what I copied. Rule 43, I'm sorry. I don't know where it went. I guess I changed it. Man, I need to practice typing. I used to type fast. I still kind of type fast. In elementary school, we had the blinders on the keys, and I had to really learn how to do that. And look up here, like, I can still go Frankie Radio Live. It's just been a while. I always look at the keys. Now it's going to do this fucking slow crap, because I want to send it to her on Facebook, but who cares? Instagram. Yeah, that's crazy, isn't it? So it already drafts me like an objection to denying order. Oh, wow. Wow. We'll come back. Yeah, I want to get a screenshot of this too for Paint. Oh, right here it says Rule 123. So it is Rule 123. So they're just fucking being like that, bro. So I almost want to go tomorrow now. Like, yeah, here's my objection. You said Rule 120. I want to talk to the judge. You said Rule 123. Y'all been lying to me on this entire case about the way that I'm moving. Wow. So I'm about to find it 3 fucking times, and I'm going to send this to them. Let's just get before and after, like you would Bible context. You know, let's read the whole fucking thing. Why not? Starting at Rule 21. You see me pull it back up. A different spot, Cherokee Nation. It's not under motions. They put it twice. They put it under motions and as 123 and Rule 123. So yeah, clear lie. Deflection, semantics. Cherokee Nation District Court rules. We'll do the acronym. Now we got it saved. Print. All right. All right. That's crazy. That's crazy. That's just the wildest shit. Now, a normal person trying to cover their ass would be like, that's not what that means. It doesn't mean you just get out of court anytime because we don't have the authority without consent. That's exactly what it means. But no, but that's what you would try to argue in this scenario. You would try to semantic your way and say that I don't know what I'm talking about. They straight up said it doesn't fucking exist. That's crazy. That's crazy. Might just retitle this motherfucker. Where's my phone? I deleted YouTube, didn't I? I tried to get fucking... Judge tells me court rule doesn't exist. I think so. Screw it. How do you retitle this fucking bastard? claim the Attorney General of Cherokee Nation lies, says clearly that Cherokee court rules. He does try to argue semantics and claim lack of knowledge for sovereign citizen rhetoric. Instead, denies claiming the rule simple procedure. Well, there it is, folks. The Cherokee Nation rule that's in here. Hold on, I gotta do the third time before I forget. Get all my shit in a roll. Just calm down. We're not finished. That wasn't it. Where's that other deal on motions? No, what I seen, it was like, well, what I seen, it was under something that didn't say rule 1, 2, 3. It just said 1, 2, 3. Let me see if I can find it again. Because down here is where we was, right? Never mind, I lied. Maybe I read something wrong. Yeah, see? Under motions. Almost there. Hold on. Let's see. Well, I thought I seen it somewhere. I guess that's it. I thought I just seen 1, 2, 3, 124. I didn't see the rule. I don't know. They said there is no rule 1, 2, 3. The fuck? Then they tried to say that I didn't state a claim in which relief could be granted. Dude. So now I'm trying to get this ChatGPT back up. It kind of helps with this, but it still kind of conflicts between verified by our cases and then what I used to it. Maybe. I'm going to turn this off, get this finished, get my objection in or whatever. Check out my sponsor.